Hello, everybody. Welcome to the Ambush Election Update and Strategy. My name is Natalie Johnson, and I will be your technical moderator. If at any point during this broadcast you are having technical difficulties, please email me at Natalie, N-A-T-A-L-I-E, at EMSIconsulting.com, or use the chat window at the bottom of your webinar menu. This chat window will also be available to you to submit any questions you may have regarding the content of the webinar. I will now turn it over to our moderator, Edgardo Villanueva.
Thank you, Natalie, for the introduction. I want to start, of course, by welcoming all of you who have taken time out of your busy schedules to join us today. I know that we have quite a diverse group of attendees today from across the country and different industries and types of companies and sizes, etc. So we want to be sure that we use our time efficiently to try to cover as much material as possible today, with the intention of enlightening you about this new regulations and new changes that are coming your way. I'm Edgardo Villanueva, President of EMSI Consulting. I have the privilege and the honor today of having with me an excellent group of panelists, experts in this field, and I want to take a minute to just let you know who they are, as well as also to give you a quick update as to how our program is going to progress. First, we will be hearing from a good friend of mine and colleague and esteemed labor attorney, Alan Kaplan of the law firm of Masuda Funai, Eifert and Mitchell. Alan will be giving us a legal update and with regards to the new NLRB quote ambush election rules. He'll also discuss about options, interpretation of the ruling, etc. I'm sure you'll be tuning in and listening closely to his valuable information. We also have today, we're very happy to have Elizabeth Melito. She is from the Chief Executive Council for the National Federation of Independent Businesses, NFIB. Elizabeth will be telling you not only about the work of NFIB, the impact of these regulations on the membership, especially in the case of small businesses, but also giving us an inside first-hand update on the congressional moves to overturn these new rules and private sector efforts to do the same, because she's been there. She's testified before Congress and in front of the National Labor Relations Board. The next panelist we have, and you'll be hearing from him also, is William, or we call him Bill Lulius. He's a senior labor relations consultant for my firm, EMSI, but Bill brings a very unique perspective to this whole discussion, in that he was an high-ranking union official, and he'll be here to talk about the union's game plan, how they are planning, and what he knows about the union's project or goals as to how they're going to try to use these rules to their advantage. At the end of their presentation, I will also be giving some input as to some of the practical proactive steps that you should be taking in order to get ready for the new regulations, which will include, which will go into effect in a mere few weeks on April 14th. Throughout the program, you can submit questions to us. I believe that at the bottom or the right-hand corner at the bottom of your menu, you can type in questions, and then we will try to get to as many of them as possible as when we conclude. So let's get moving, because we have a lot of material to cover. As I indicated, we're going to hear first from Alan Kaplan, Alan, please proceed with your information.
Thank you, Ed. I'm pleased to be representing Masuda Funai. We are a business-oriented law firm, mergers and acquisitions, corporate reorganizations and financing, commercial real estate, sales and distribution networks and agreements, commercial contracts, business-to-business litigation. Our employment, labor, and benefits practice group represents management. Our focus is on flexibility and management rights. We advise clients to ensure corporate compliance, counsel clients on issues from hiring to terminations. We draft and negotiate employment and union contracts. We advise settlement, but when necessary, we are not afraid to litigate. I was a hearing officer, investigator, and prosecuting attorney for the National Labor Relations Board. But before you get angry, I'm one of the people who prosecuted the United Steelworkers for an unlawful secondary boycott against U.S. Steel. I also prosecuted the Teamsters for an unlawful hot cargo clause in its union contract. Now, I know that these detailed, and some may say arcane rules are frustrating, but they can be used to defend companies and also for companies to try to win against unions. In other words, we use these regulations as we use all regulations to gain advantages for companies. But these new regulations require new actions. These new regulations were published on December 12th, and they will become effective on April 14th. Why are they important? Well, let's look at the union win rate now. What do you think it is? Well, it actually is 66%. That's now without the new regulations. Unions go to elections only when they think they can win. The new regulations will help unions win. The new regulations are also important, especially in light of what we call the iceberg principle of union organizing. Your company will now have less time to react and defeat a union campaign. For weeks or months, the union campaign will be like that iceberg that sunk the Titanic. The employees' activities are secret and hidden from management. For those companies without what we call an ever-ready campaign, the first time they hear about the union is when employees start wearing union buttons and announce union meetings. It's almost too late at that point. Sometimes the first time a company finds out is when the labor board's investigator calls them and tells them a union has filed a petition asking for an election. Well, what hasn't changed under the new rules? What happens once the union files a petition? What happens is that the union only needs 30% of the employees in the unit to sign authorization or membership cards. For example, for a well-known grocery store restaurant in Chicago, there were just 8 operating engineers working on the HVAC system. The union needed only 3 signatures to get an election. The first step is preparing for the hearing and whether the company will sign an election agreement. And that hearing will take place within 14 to 16 days under the current regulations. What is the appropriate unit for the union to represent? That's something that will have to be discussed and looked at. At a small hotel near St. Louis, we had to decide whether or not the housekeeping employees were in the same unit as the food and beverage workers. We also had to think about their supervisors and team leaders. Are they eligible to vote? If there are no issues, the company will sign an election agreement. It lists the employees included and excluded from the unit and sets the date, time, and location of the union election. When the union and company disagree, the labor board holds a hearing. The regional director issues a decision, a directional election, and then the company must post a notice telling the employees about the election and who can and cannot vote. In the meantime, the company can ask the labor board in Washington to review the regional director's decision. The labor board may delay the election or impound the ballots, but the company's campaign must continue. The union wins when it gets 50% plus 1 of the votes of the employees who vote. Therefore, during the weekend before the vote, both the company and the union count votes. Although unions are winning over 60% of the elections, unions are also withdrawing more than 30% of the petitions they file. They withdraw because the company has had enough time to campaign against the union and convince the employees to vote against the union. When a union withdraws a petition, it can refile it within 6 months. When the union loses the election, the union must wait 1 year before filing another petition. After the election, they'll file objections to overturn the results of the election, or the company or the union can challenge the right of a voter to vote. A hearing determines whether or not there was conduct to overturn the election or whether the challenged votes will be counted. So what has changed in this process? How do the new regulations decrease the time between the filing of a petition and the election? Under the new regulations, most pre-election issues will be decided after the election. Importantly, the new regulations eliminate the 25-day waiting period for the election. The ballots will not be impounded. Washington will not accept every request for review of a regional director's decision. And the regional directors will not have the number of hearings they currently have. This means that the union can have the election as soon as it wants. If it has filed a petition with 70% support, and it usually waits until it has 70, 80% support rather than the 30%, the last thing the union wants is a delay. Therefore, the number of days between the filing of a petition and the election could be as little as 10 to 14 days rather than as many as 42 days now. The regulations include other changes that help unions. Currently, a company posts a notice about the election after the election date is decided. Now, however, the company must immediately post a notice of the filing of a petition telling the employees about the union election. This gives needed publicity to the union. The company must also give the union a list of the names of all employees in the unit petitioned for by the union. Therefore, even if the union has support from only 30% of the employees, the union gets a list of 100% of the employees' names, jobs, shifts, and work locations, a real advantage. In addition, hearings are limited in scope. Whether team leaders or supervisors may well not be litigated before the election. The issue may be litigated after the election takes place. This is because a company can still challenge the ballots of the team leaders. If the number of challenged ballots may affect the results, a hearing will take place, but after the election. The team leaders will still have voted. The labor board will then determine if the team leaders are supervisors or employees and order the ballots counted. There are many other technical changes that really interest only lawyers, but for companies, one of the most controversial regulations states that the ballots will not be impounded. You must be ready. We recommend implementing what we call the Ever Ready Anti-Union Campaign to determine if you are vulnerable, to take action to be union-free, and to prepare now for a union campaign. However, what's interesting about the new regulations is the old saying, what's good for the goose is good for the gander. Ed and I recently represented a small manufacturing company where the employees told management that it no longer wanted to be represented by a union. We helped the company file a petition for an election for the employees to vote out the union. The company had to wait 6 weeks for the election. During that 6 weeks, the union campaigned in its support. Ed was in charge of the campaign on behalf of the company. And again, fortunately, because of Ed's persuader activities, the union lost the election. The company is now union-free. Under the new regulations, the timing for that election will be lowered. And now to introduce our next speaker is Ed.
Okay, Alan, and this subject that Alan just touched on of decertification and how these regulations can actually work in favor of that, we'll discuss it a little bit further in more detail down the road, because it is something that's catching the attention of many companies that already have unions in some or even in all of their, or most of their workplaces. Thank you again, Alan. Next, we have Elizabeth Milito. Elizabeth is, as I mentioned, the Chief Executive Counsel for the NFIB. I had the pleasure of meeting Elizabeth when she and I both testified in Washington in front of the National Labor Relations Board, actually arguing against these regulations about a year ago. it seemed clear to us and to all the other panelists that were on the management side that the board had its mind made up. But it was an opportunity to meet with her and the work of the NFIB, which she will discuss, and also some other key things, including her firsthand knowledge of the congressional activities aimed at trying to overrule the NLRB ambush election rules. So Elizabeth, welcome, and I turn the audience over to you for your valuable information.
Thank you so much for inviting me to speak today, and thank you all who are out there tuning in and participating, because this is a really important issue to keep track of. And unfortunately, I'm going to get to the point that although we here at NFIB and many other associations here in Washington are kind of going full throttle and trying to stop the rule, it's not looking promising. And I think come April 14th, this rule is going to go into effect, despite our best efforts. Just a quick shout out to NFIB, an organization that I am proud to work for and have worked for now. I'm going to my 12th year here. We represent 350,000 small and independent businesses throughout the country. The only criteria to belong to NFIB is that you be independently owned and operated. But that said, by and large, the majority of our members are small mom and pop type businesses. So they average under 10 employees or less. So they're pretty small. And the question I might get, is, oh, well, is this really an issue that your members need to be concerned about? Absolutely. And it's something we hear about from our members. They're very concerned about it. A few years ago, we put together a guide to handling union organization efforts, and it is one of our most popular publications. So that just shows that this is really an issue that regardless of the size of your organization, you need to be concerned about what the labor movement is doing out there. I think if you can I don't know that I can flip to the next slide there. Just a little bit of thank you, a little bit of background too, Lane. I say the political context, if you will. The National Labor Relations Board has really devolved from being a neutral arbiter between unions and employers to being very pro-labor, really an arm, if you will, of big labor. And I put this quote up here because this is how far the NLRB is now going to protect employee rights. This is a real post that an employee made online. The employer terminated the employee and challenged it with an unfair labor practice. So that just goes to show you, I think it's really indicative of how far the NLRB has come and unfortunately what it is employers are dealing with. I mean, the NLRB is, make no mistake about it, out there to help unions and increase the number of employees that are in a collective bargaining union. So turning then to the ambush election rule itself, the election rule on the next slide there, again, commonly referred to by insiders and labor experts as the ambush election rule because of its focus on speeding up the union election process at the expense of employees and employers, who employers are really going to have insufficient time to understand and address the relevant issues about the impact of unionization. As Alan said, the organizing effort is going on behind the scenes long before those buttons are likely appear on your employees' lapels. NFIB here, we've long supported the fundamental right that's guaranteed by the National Labor Relations Act of every employee to make an informed private choice about whether or not to join a union. And as Alan pointed out, while estimates vary, elections could now occur in as little as 11 days after the employer is notified of a union and election petition. So 11 days, I mean, not even 2 weeks. In addition, the rule severely limits an employer's ability to challenge aspects of the process, the union petition process prior to the election. It really, overall, the rule promotes the speed of elections over all other goals and requirements of the National Labor Relations Act. And it's just not going to provide an opportunity for a full and informed debate before the election is held. NFIB is very concerned about the rules mandate also that employers provide employees' personal phone numbers and email addresses to labor organizations. In many small businesses, the employee is giving this information, private information, home telephone numbers, maybe email address, really the home phone numbers, for emergency contact purposes only, not knowing that it's could potentially be given out to a union. And then I just want to, and I apologize, I was flipping around there too. I do want to touch upon the fight we're putting up here and outside Washington. Organizations are putting up to try to stop the rule. So far, unfortunately, unsuccessfully. Legislation was introduced in the Senate and in the House, known as the Senate Joint Resolution 8, which would have nullified the rule. It passed in the Senate. It passed in the House by overwhelming margins. But we fully anticipate that the President is going to veto it because he has been very supportive of this labor board and of this rule in particular. Knowing that Congress is probably going to be unsuccessful in its effort to stop the rule, two lawsuits have been initiated to stop the rule. One was filed by the U.S. Chamber of Commerce, the National Association of Manufacturers, the Society for Human Resource Management, the Coalition for a Democratic Workplace, and the National Retail Federation. They filed one lawsuit here in federal court in Washington, D.C. A second lawsuit was initiated then a few weeks later on January 13th by the Associated Builders and Contractors and NFIB. And it was strategically done to file lawsuits in two different areas of the country so that we could get opinions from ultimately, hopefully, two different federal circuits. Unfortunately, again, the courts have not issued a ruling. So again, underscoring the fact that this rule is going into effect as of right now on April 14th. There's no indication that either court is going to issue any sort of stay or issue a ruling that would stop the rule before April 14th. So employers should prepare to comply with the rule. That's what I'm telling my members, and that's what I'm hearing other, labor experts, labor attorneys like Alan tell their clients too. You need to prepare. You need to start with the messaging, getting your business's message out to ensure that you're exercising, you have time to exercise your free speech rights as an employer there. So very important, again, to start working on your messaging and prepare for this new rule, because I think we're going to see a flurry of petitions filed come the end of April. That's what I'm hearing, and that's what I anticipate too. So I think the last slide there has my contact information. If anybody is interested in a copy of, we have the Employer's Guide to Union Organizing that I mentioned, or anything else NFIB related. And again, thank you so much for inviting me to participate today.
Well, that was a lot of important information in a brief amount of time. Thank you, Beth, and I know that there is so much more to come. I really, as you say, I want to extend again publicly my sincerest gratitude for participating with us today. I think you bring a very important message from right down in the trenches there where you're at in Washington. So we'll have a chance to hear from Beth again, and again, if you have any questions that you'd like to address to either Alan, Beth, or our next speaker, Bill Lulias, or myself, please type them in, and we will have allocated some time at the end of the presentation in order to address as many of them as you can. I will also mention, and I'll probably repeat it, that if you have, a particular interest in discussing your particular situation with us, for certain we'll be available and would be very willing to speak with you. I think we've advertised that any participants in this webinar will be entitled to, a free consultation, 60-minute consultation to address the situation at your workplace. Okay, next up we have a new member to our group, and when I say group, I mean to EMSI Consulting. Bill Lulias is a senior labor consultant with us, and of course he brings a very unique perspective to the whole subject of unions and what their strategies are, because he was in fact on an ex-high-ranking union and Teamster official, and Bill will give you a little more of an update about his personal bio. But we want to hear from Bill in relation to this subject and so forth. what he can share with us based on his years and years of experience from the union standpoint. What is their game plan? Beth just mentioned it is highly anticipated there's going to be a flurry of petitions coming, and the unions, because the unions certainly know that this new change in game plans or give them an advantage. So I'm going to turn it over to Bill to share some of his insight and experience with you, and I'll be back afterwards to address some other closing points. So Bill?
Okay, thank you, Ed, and hello everyone. I'm glad to be here. This is a very important webinar, and I hope you can get all this information out to whatever contacts you have out there, because this is real and it's really happening. I was 22 years as a union member, part of the Teamster Rail Division. I was an elected union representative, and my territory was 12 states in the United States and 1 province of Canada. I represented quite a bit of bulk of the membership. I was also elected as a delegate to the Teamster conventions. I lobbied in Washington, D.C. on behalf of the Teamsters. I was a employee member of 3 public law boards. I've done many grievances. I've done the whole gamut. So I know what's happening out there right now. I still have contacts within the union, and we can go through some of these things as we go through this presentation. If I can go to the next slide there, Natalie, please. Everyone thinks, and Elizabeth pointed it out, that the National Labor Relations Board used to be a neutral that would basically administer the National Labor Relations Act, but those things have changed. As you can see here, here's a notice for training for the new election rules. And if you look at the highlighted part to the right, it says it's actually it's going to happen this Thursday, and it's going to be held, the presentation by the National Labor Relations Board is going to be held at the SEIU offices on West 18th Street, New York City. You talk about bias, there's a bias right there, but on top of this, and I mentioned this in one of my blogs, the National Labor Relations Board went on a social media campaign starting February 4th of this year to all non-union workers that that they could. It was like basically tweet blast and email blast to, and I don't know how they got the emails and the tweets, but they put a social media blast out there to promote this new rule and to promote what they do and how they can help non-union workers. So if you think that the National Labor Relations Board is there to help, they really are not. Can we go to the next slide, Natalie, please? As you can see from this slide here, union membership from 1983 to 2012, and this again is we don't have 3 years of data. This is from the Bureau of Labor Statistics, and they have not updated the chart. Union membership has been on a downslide since 1983. In the private sector right now, I believe it's 6.3% of the workforce is unionized. And I think including the public sector, it's 11.5. But the public sector includes school teachers and government workers and police and firemen. So the unions are basically desperate for new members, and they're going to take advantage of these new rules. And they're desperate for new members for a number of reasons, but the big reason is this year 150 union pension funds are in critical status according to the government. So they're in dire need of money. So they need to pump up the membership, which has been in basically a downslide since the 80s. Next slide, please, Natalie. And here's what the unions, from what I'm getting from my union contacts, are telling me on how they're going to implement their tactics come April 14th. And what Elizabeth said is absolutely true from what they're telling me. It's going to be a tsunami of petitions to come in for union organizing, because they're going to take advantage of this shortened election cycle. The first tactic that they're doing, and they're doing this right now as we speak, is they're salting the workplace. And for those of you who don't know what salting is they take a union, someone that works for the union, and they have him or her hire into the workplace. as a worker, and we've even had some cases where they hire in as HR directors, HR managers, payroll people, someone that comes into contact with the workers all the time, and they start promoting the union in a covert way. And then after they get established, they have the union organizers show up. And it's a very orchestrated tactic that they've used for years. We ramped it up in anticipation of April 14th. The next thing that they're going to do, and they're utilizing this already, is using the social media for media blitzes. And with the new rule, they're even going to have more latitude, because now they can use company email to promote union organizing tactics. And this, coupled with the National Labor Relations Board, is really a two-fisted punch, if you will. The other thing that they're doing right now is they're recruiting and training new organizers. You can go on to even Indeed and Simply Hired, and you'll see in there that they're all hiring union organizers, anywhere from $15 an hour to $40,000 a year. And there's one thing that most people don't know, that union organizers typically are not union members. They're at-will employees that work for the union, so that means if they don't meet their quotas, it's like a sales job. If they don't meet their quotas, they get fired. And it's a very obscure kind of relationship, but that's what they do. But that recruitment has been going on for over a year now in anticipation of this new rule that's going to take effect April 14th. And in conjunction with that, these community work centers are also hiring people, and you can see that on these hiring sites like Indeed. And what community organizing the work centers are, if for people who don't know what they are, they're not considered labor organizations because by law they don't have a relationship with a collective bargaining agreement with an employer. So they're not considered labor organizations by law, so they're not under the scrutiny of reporting of finances. So they don't charge dues, but they charge a fee of membership per year, which is a small fee, but it adds up because some of these work centers have over 17,000, 20,000 members. And what they do, this all changed. Work centers started as a place to help people get work, but this all changed in 2006 with the National Day Laborers Organization Network, the NDLON. And they partnered with the AFL-CIO, and they started out with 60 work centers. And actually the AFL-CIO, and what they did is they help embrace immigrant workers and get them jobs. And this was a major policy change for the AFL-CIO, who did not embrace immigrant workers. They embraced the American worker. It was actually a conflict then. But now because the membership is so down, they've changed the whole paradigm. They've mushroomed from 60 work centers to over 200 today. And they're working closely with unions like the SEIU, Unite Here, and several others. And it's becoming a very big thing because it's another covert way of getting in the community, getting community support for a union organizing campaign. I did a campaign up in northern New York State where the whole community was involved in supporting the union organizing drive, including the newspaper. And that was a very, very tough campaign, but this is what these community organizing work centers do. All these four things they're doing in conjunction in anticipation of this April 14th date, and they're going to really hit it very hard. And it's going to be pages and pages of petitions coming in. Just to give you a little brief, 2-second history here of how the unions have evolved. Samuel Gompers, back in the late 1800s, he was the founder of the American Federation of Labor, which is the precursor to the AFL-CIO. He said that the worst crime against working people is a company which fails to operate at a profit. They were concerned at that time that, yes, they wanted better working conditions and pay for the people that were working, but they also wanted businesses to succeed. Today, that's not true. They couldn't care less if you went out of business. There was another organizing campaign with the SEIU up in Connecticut several years ago where they actually ended up going on strike. And the SEIU representative said he didn't care. He told this to the news media. He didn't care if they made pizza parlors out of the healthcare facility. And in fact, as a result of that, they did close down, and all those people lost their jobs. So it's a whole different outlook now on how they do this. They only want union membership for dues, and that's all they care about. And I'll turn it over to Ed right now.
Yeah. Okay, Bill, thank you very much. It's time I have a conversation with Bill, I learn more about the inner workings of unions and how they think, and that's why he brings such a valuable insight and information. I'm going to just take a few minutes here to address a few quick things that, in my 32 years of experience in working with management, because we work side by side, we become a team with management, and we promoting positive work environments, and obviously promoting union-free work environments. What I've learned in a nutshell, in an abbreviated version, pardon me, as to why people turn to unions. And I'll just go through this real quick. Most people would put number one reason is the reason people go to a union is because they want more money. And it's true, nobody does it, but it's also about your pay practices. Are they inconsistent? When it comes to benefits, when people feel like they've lost a benefit or it costs them more, they say, well, maybe a union can control it. Unsafe work conditions are always part of the argument that I hear when employees tell me, well, they just don't pay attention, or the roof has been leaking and they never do anything about it, etc. The issue of insecurity in their jobs, can they get fired for, because a supervisor comes to work with a bad attitude one day or whatever, causes people to run to a union. And of course, the next one, seniority, is a word that unions love to throw around. But while it doesn't have to be a strict seniority like in a contract, most people feel that if they've given your company X amount of years of service, that should, basically grant them an opportunity for better pay or promotions or so forth. And it's not always the case in companies I visit. In terms of issuing communications, people feel that they're not being kept in the loop or not told about policy changes, or, oh, gee, who's that new guy? Well, he's your new boss. Really? Nobody told us, etc. That kind of stuff can lead to a feeling of distance from the company. Discipline issues, of course, if there's inconsistency, if there's favoritism on the part of your supervisors, that's going to get people to want to turn to an outside representative. When there's the issue of lack of promotions or no sense of being able to move up in a fair and consistent way, obviously people will also be looking to outside representation to help that. You also have to have a certain amount, if you're a non-union employer, be attentive to people's personal problems. Issues come up, and if you can be flexible with it without violating your rules, that creates a bond and therefore eliminates the need for people to want to look to outside. And then the last one is one that I've heard everywhere I've gone, and people feel like the response to any complaints that they have or any issues is, if you don't like it, there's the door. I can almost guarantee you that's going to be on the top of people's minds when it comes to the idea of whether or not to support a union. Be glad to talk about this more in detail with you and how it relates to your situation. So what are some of the action steps we recommend in light of all the information you've heard in this presentation? Know your people. Get to know them. Make sure that you understand who they are, who you're hiring. Bill mentioned the idea of salting the workforce. You have to be very careful as to how the process is conducted legally so that you're not, allowing yourself to be infiltrated that way. Know your leadership team, the people on the front line, your lead people, your supervisors, of course managers too, but the people who are face-to-face daily with your workers are going to make or break it when it comes to whether or not you're prepared. So you've got to train them. You've got to give them proper information. As Elizabeth mentioned, she's recommending to all NFIB members, you got to teach people about, union avoidance and tactics that they use and what to be on the lookout for. We've done a lot of these programs recently. Know your company, understand your rules, your regulations. Do you need to make changes now in your handbook before it's too late? And lastly, know your rights. Many managers are sort of frozen when it comes to, what do I say? I can't say this, I can't say that. On the contrary, there's much you can say and much you should say, not only up front, up now, but for sure in the case of a union petition, but now you won't have enough time. Okay? I just want to quickly walk you through what would normally be a typical campaign situation under the current rules, under what we're living with today. And typically we walk in with, we'd have 5 weeks or so, 4 or 5 case. Week 1, we talk about planning, scheduling, supervisor do's and don'ts, etc. Week 2 of meetings with the employees, we talk about union finances, the rules, regulations, and stuff. These are, you still have a business to run. Week number 3, we might talk about collective bargaining, what the reality is, what the law says about it. It's not a give, but it's a give and take situation. Week number 4, we would talk about strikes and job security. And then as we wrap up a typical campaign, we're looking at the final week of details and speeches from the executives and so forth. So there's much more to that, but ask yourself the question then, how are you going to fit all this if it's only 10 to 14 days? How are you going to fit 5 weeks into 10 to 14 days? When I testified in front of the National Labor Relations Board, Chairman Pierce looked at me and said, well, you have access to these people as much as you want. And it stunned me that was his perception, that somehow a business could close down and huddle up with people for 10 days, not conduct any business at all, especially if you're a small business, etc. But the answer to that question is, you got to find a way, or you got to get started ahead of time. Okay. I want to just add one last thing, and this is relating to what a case that recently has been much more public, called the Purple Communications case or ruling. Okay, this is where in-house union supporters or union organizers, employee organizers, I should have added that word, can now use your internal email system to communicate the union sales pitch to your workers. That is, your own employees now have access to your email box. So the question is that you need to answer is, are your current email and social media policies up to date in order to control this should a union launch an organizing campaign? It's very important that this ruling now be considered immediately as something that needs to be done in your workplace. Lastly, I want to talk real quickly about something that Alan mentioned earlier. Decertification. He called it, whatever is good for the goose is good for the gander. But here's the story. If your employees have voluntarily expressed their dissatisfaction with unions, and I know some of you out there probably have unions in certain aspects, segments of your business, okay, then you have to listen for what I call the magic words. If they've expressed their dissatisfaction and said something like, how do we get rid of this union? Or is there anything we can do about it? Or something to the like. Then I have, first of all, I have one immediate information. Call us. Call us with that information. And we'll help you to look at your options legally. Okay? There are basically, and this is, I'm not the lawyer here, but there are 2 legal ways to decertify a union, to be rid of them. One is an RD. Most people know that. Decertification petition is driven by the employees themselves. They sign, they get signatures, they have to go down to the labor board, they have to file this, and they have to fit it within the window period, and on and on. Sometimes very complicated. And of course, as Bill would mention or indicate, the unions don't like that. The second way, though, is another one that most companies don't know about. It's an RM petition. Alan and I have successfully used this with several clients where management files a petition. Once again, the details depend on your situation, on your contract, etc. Okay, so we, so we will definitely look at that. Now, interestingly, the subject of deauthorization is another option to explore during this time, and we're getting calls about that. Most people really don't understand what deauthorization is all about. I'll say it in a nutshell, and if we have some time, maybe Alan can amplify a little bit on it, but I certainly, it basically means that even if you have a contract that has a union security clause, there is a legal option whereby your employees can opt out or choose not to pay union dues. Okay. Again, these are processes that are unique to each situation, and have to be carefully looked at and so forth, so as to not violate the National Labor Relations Act. But it is an option that people are submitting to us questions about, and in fact, I see that there are some questions, and I want to try to get to some of them from the audience. Okay, well, that pretty much wraps it up, but I'd like to maybe give just a few seconds, maybe 20 seconds or so, to each of our panelists to just summary, so that we're not overlapping our time here. But Alan, you want to go first?
Well, sure. I think to wrap up, it's important to realize that really everyone needs this ever-ready anti-union campaign. This includes a vulnerability audit. It also includes a union avoidance action plan. That's reviewing your organization, identifying the units, identifying who is a supervisor, reviewing and revising unlawful policies, drafting, implementing policies that can help you fight union organizing, training supervisors, and implementing employee relations procedures. Remember, an issue-free workplace is a union-free workplace. Elizabeth?
Thank you, and I would just add on to that union avoidance is an ongoing process. Actually, it should be going on all the time, regardless of whether there's a potential petition on the horizon. And I know EMSI has some great training that can help you communicate with your employees. And I just think that's so important that employers, businesses understand that union avoidance should just be ongoing. And it's about communication, open communication channels with your employees.
Bill, any final thoughts quickly, because I know our audience is borrowed time right now. Go ahead.
Yes, basically we turned the organizing tables on the union, and it's always communication, and campaign that you're guaranteed to win is the one you never have. So I'll just leave you with that.
Okay. I'm just noticing here real quickly for those of you who are still here, and I noticed that most of the audience is still with us, and I really appreciate this. We told you it was going to be tough to compress all this important information. One question said, will copies of the presentation be made available? Absolutely. You can please write to us, and we will get those to you immediately once they're prepared after our presentation today. Okay. There's a couple of quick audience questions, and I apologize to the audience, but I'll go ahead and throw these out, and hopefully you can give us another few minutes of your time. And I think this is something that maybe Elizabeth can address real quick. Elizabeth, somebody asked, well, after the presidential veto, are there other options left, or is there any other options for attempts?
Yes, a good question. The other option is, of course, the lawsuits, and we do have high hopes for the litigation, but it's not going to be a quick fix. I mean, here at NFIB, we're prepared to litigate all the way up to the U.S. Supreme Court if need be, but again, that's not going to happen before April 14th, unfortunately.
Okay. Alan, I think the next question, another question is, what if a company has no email, for the workers, but yet these new regulations would call to submit emails? Should they go out and seek them, or what should they do if they don't have them routinely?
Yeah, no, if a company doesn't have the emails, you don't have to give them out. You don't have to go ask the employees for them. That's
concise and to the point. Yeah. Bill, somebody asked about right to work states. In situations like that where you cannot be forced to be a member of the union, how do unions appeal to workers in an organizing drive?
That's a good question. I get asked that a lot. A lot of companies in right to work states say they don't really need any help in thwarting off the union, where in fact the union organizing drives now are geared towards right to work state, and actually they have a vendetta out for Wisconsin, so they want to make a point. Their sales pitch now is that, what do you have to lose? Try us out. If you don't like what we do for you, you don't have to pay us. They get their foot in the door, and a lot of times these union contracts only allow you to opt out of the union once a year for a one-day period. So you have to be very careful.
Okay. Very good, yeah. And there was one more about the subject that we just briefly touched on deauthorizations and how that process works. Again, it's very similar to other NLRB type elections, but there are some significant differences, and it depends on your situation. But the two things to remember, one is a deauthorization election can take place at any time during the life of a contract. It doesn't have to be a window period at the end of the contract, as is the case in decertification. So once again, we'll look forward to questions in much more detail and seeing how they pertain to your organization. So I really appreciate it. I see that a large part of our audience is still here listening, and as you can see, it's kind of tight to try to get all this information in an abbreviated period, but we look forward to following up with you, to your inquiries, to your questions, and of course, all of us look forward to being of service to you. Thank you once again to the panelists, and most importantly, thank you to all of you for attending our program today, and we'll see you the next time.
Sayonara.